The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. I have with me on my podcast today one of the most effective and determined court watchers out there, Lisa Graves, who has been on this show before and has done some of the best research into the corrupt billionaires' scheme to capture the United States Supreme Court. Welcome, Lisa. It's a treat to have you back.
Oh, gosh, it's nice to be back on, Senator Whitehouse. Thank you for inviting me.
Let's kick off with the latest coming out of the courthouse in the Eastern District of Virginia, where Trump's purported U.S. Attorney, Lindsay Halligan, is having a hell of a bad time. The latest aspect of the terrible time she is having being the court's determination that she misstated the law to the grand jury in seeking the indictment, that she urged the grand jury to consider facts not in evidence, that she had not shown the grand jury, but that she said that she had and could produce at a later trial, which is also improper. A grand jury is supposed to be making a decision based on the evidence actually presented to it, even if it's presented in summary form. Yep. And then perhaps most weirdly, and perhaps also most devastatingly for her, it looks like she might have switched the indictment documents without telling the court what was happening. What do you see in all of that?
It's just simply extraordinary. These are the types of mistakes that you would expect from an unsupervised rookie beginner attorney, and you wouldn't even expect them, really, because that person would have been supervised by someone who had actual experience. And so it reveals, in some ways, just the shoddiness, the faultiness of this entire process, where Donald Trump has orchestrated the removal of experienced attorneys who were against these indictments, did not think they were well-founded in fact or law, and instead had them replaced with someone who was an attorney for him and someone who had been working in the Trump White House, who has no experience as a federal prosecutor or experience of this kind, and it appears, based on the allegations, to have not just bent the rules, but broken them in ways that I think really do impair this prosecution, leaving aside the fact that she was improperly appointed as an acting U.S. attorney in the first place, a failure that Pam Bondi tried to correct by somehow substituting her in as a special attorney. She is not very special. Other than that she's so loyal to Donald Trump, she'll do anything, apparently, to try to get the indictments that he wants against his enemies.
So I had Attorney General Holder on in the last one, and I went through some of the things that federal judges have said about Department of Justice presentations in their courts, using language that, had it happened with my U.S. Attorney's office in my United States federal court in Rhode Island, we would have been all over that DEFCON 1, because that's just not the kind of language that a federal judge should ever be using about a U.S. Attorney's Office or a Department of Justice lawyer. And yet it's now commonplace. Here is the actual language from the magistrate judge in the Eastern District of Virginia. The Halligan gave the grand jury, quote, a fundamental and highly prejudicial misstatement of the law. The government's actions in this case, whether purposeful, reckless, or negligent, raise genuine issues of misconduct, and the disturbing pattern of profound investigative missteps could have undermined the integrity of the grand jury proceedings. That is bombshell language in any normal Department of Justice.
That's right. That would ordinarily trigger an internal investigation from the professional ethics part of the department that is supposed to make sure that U.S. attorneys and assistant U.S. attorneys are following the guidelines and not engaging in misrepresentations to a court and including to a grand jury where, as you know well, Senator, prosecutors have special duties to not misstate the law, to not provide prejudicial interpretation of the law to those grand juries, to not impair an indictment. And so it really is extraordinary. This is the type of thing that would warrant repercussions internally and possibly repercussions with the bar.
So let's cross the river from the Eastern District of Virginia back into the District of Columbia to the federal courthouse there, where the big news is that the United States Court of Appeals for the D.C. Circuit has cleared the chief judge in that court, Judge Boasberg, to go ahead and look into whether there was contempt of court by the MAGA Department of Justice in the proceedings related to the illegal deportations. So that's where it stands, but it has a surrounding, which is that MAGA has really gone berserk trying to stop the contempt hearing from going forward and indeed trying to discredit Judge Boasberg and disable him from going ahead with that contempt investigation. They really don't want to have him looking into this. And that included a bunch of Republican senators writing a letter to the chief judge of the D.C. Circuit Court of Appeals asking that Judge Boasberg be suspended because there was one of these MAGA impeachments pending against him over in the House. So this is one of many assaults on Judge Boasberg that they've engaged in, including two Trump appointees on the D.C. Circuit stopping his proceeding, which would have looked into the alleged misconduct of a DOJ official, Emil Bovee. And even though an administrative stay, the tool they used, is only supposed to last days or maybe weeks at worst, they left it in place for 4 months, which gave the MAGA DOJ the time to shove Emil Bovee through the Judiciary Committee, and now he sits on the United States Court of Appeals for the Third Circuit. So to go back and blow up Emil Bovee with potential contempt determinations in Judge Boasberg's court, in addition to wherever it leads in the Department of Justice and through the Trump administration when discovery happens, you can see why this is a hand grenade for them, and they're going out of their way to attack Judge Boasberg in unprecedented and brutal ways. Are you watching that scenario play out also?
Yes, very much. And this is a sign of the actual contempt for the rule of law, for justice that has been displayed by Team MAGA. And Team MAGA includes this Justice Department with Bondi at the helm, where Bovee was also a top official within that department, as well as these Trump appointees on the D.C. Circuit who have acted in this extraordinary way to try to prevent there from being any accountability for the comments that Bovee made and the actions that this administration took, in essence, in defiance of court orders. This is another area of extraordinary, exceptional, unprecedented behavior by this department. But in this instance, it has also been aided by Trump appointees on the D.C. Circuit. And I do think the logical conclusion is that this was an effort to stall things so that Emil could get appointed to the Third Circuit Court of Appeals, where, in my view, he should not be entrusted with a position as being a U.S. Court of Appeals judge or a judge at any level in the court system, given the evidence that was presented of what he was saying about urging other lawyers in the Department of Justice to defy the orders of the court. You should not be rewarded with a judgeship when you've this is not some ancient history. It would be troubling if it were, but just earlier this year in some of the most important cases that the courts are considering, it's extraordinary. And the personal attack on Judge Boasberg is also outrageous and extraordinary. He has been complying with the law. He is an experienced jurist. He's been acting with the same behavior that courts expect, which is candor from the parties, that the parties will not mislead the court, that the parties will comply with court orders, or in fact, they do risk being held in contempt of court, and rightly so. And so this is another extraordinary instance where you have this deep politicization of the law, an effort to use the law as a weapon against judges who dare to actually apply the law.
The attack on Judge Boasberg not only had the recent letter signed by a bunch of Republican senators, there was a previous letter signed by another bunch of Republican senators also attacking him over having allowed the government to do the toll records after January 6 and keeping that sealed while the investigation proceeded. So there are two avenues of attack from Republican senators. And then Attorney General Bondi got wind of what she thought was a comment made by Judge Boasberg in the judicial conference. And she's filed a disciplinary complaint against him on behalf of the Department of Justice because of that alleged complaint. So you know what the judicial conference is. Why don't you explain for listeners why a comment made in the judicial conference is an unlikely basis for judicial misconduct complaint?
It's another case of an exceptional circumstance, a really outrageous circumstance. The judicial conference was created by Congress as a way to have an administrative body within the judiciary. It was not created by the judiciary. It consists of the chief judges of each of the circuit courts, as well as representatives from the district courts. And the job of that body, which is helmed by the Chief Justice of the United States, although I think they've failed in some ways, but one of his jobs is to ensure that judges follow ethical codes, that they would make a referral if there were violations of ethical codes and more, and in essence set the internal policy for the judiciary.
It's administrative. It's not
yes.
adjudicative. Nobody's
no, it is not
rights
adjudicative.
or liabilities get decided there. It's purely administrative. And
yes.
Is it not also considered to be private and internal?
Yes. In fact, it is supposed to be private and internal for the third branch, for the judiciary. And the idea that someone would share information from that meeting with the Justice Department to try to weaponize alleged conversation is also extraordinary. It shows you that, in fact, some of the judges who have been appointed by Trump are not necessarily acting as judges ordinarily do.
Well, let's assume for a moment that the statement supposedly made by Judge Boasberg in the judicial conference actually was made by him. He is in a room full of some of the most distinguished federal judges in the country. The Chief Justice sits at the head of the table presiding. What Attorney General Bondi is suggesting is that in front of all of them, an act of judicial misconduct meriting discipline was performed and none of them noticed.
Yeah.
It's kind of hard to have that make any sense. But to me, it's a sign of how very desperate the MAGA attack is to try to stop that contempt hearing at all costs.
And in fact, when you think about Pam Bondi's behavior, including her behavior before the Senate Judiciary Committee just a month ago, which was with such contempt, to me, it's quite clear that we, the taxpayers, are paying for her to act as though she continues to be a criminal defense attorney for Donald Trump and for his political party, his agenda, and not actually acting as the person who is supposed to be fairly administering justice at the helm of the Justice Department as the nation's top law enforcement officer. And this is yet another example of her use of extraordinarily reckless rhetoric and trying to use her rhetoric to claim that this judge behaved inappropriately in a judicial administrative meeting. It just defies all logic and imagination unless we see her not as acting in reality like an attorney general should, but as someone who is determined to aid Trump and Trump's agenda at any cost.
Ditto Todd Blanche and his extremely bizarre interview with Ghislaine Maxwell down in Tallahassee, Florida, which was just peculiar in the extreme and, as you say, inexplicable if you see him as acting as the Deputy Attorney General of the United States, but completely explicable if you see him as acting on behalf of his former client, Donald Trump, individually, who is waist deep or better in the Epstein muck right now.
Todd Blanche is another person who was previously hired as a criminal defense attorney for Donald Trump, as Halligan as well. It is his former defense counsel playing a public role, having public offices, and yet using those offices to protect Donald Trump. And that Maxwell interview, it is so at odds with the evidence and material that's been released by the House Democrats. It's at odds with what we've seen in the reporting record in terms of the relationships between Donald Trump and Maxwell and Epstein. It's at odds with Trump's own statements about his best friend and more. And yet now, as a result of that staged, quote, interview between Donald Trump's former defense attorney being paid by us as Deputy Attorney General, now she's at this country club facility where she's reportedly getting takeout and treated like she's staying at a hotel, and not as someone who's been convicted of serious sexual trafficking related offenses, and someone who, before he, quote, interviewed her, she had a record in civil cases of basically denying the claims of people who had bona fide testimony of her actions toward them, not just one, not just two, but multiple young women, talking about her predatory behavior. And in my view, she has a record of attacking those victims. And yet here we have this administration rewarding her with that transfer from a prison that she was duly sentenced to and should still be serving at to this country clubs-like environment. And we hear on a regular basis, when will he commute her sentence or actually release her or pardon her? It's extraordinary.
And for what it's worth, our repeated requests to the Bureau of Prison for any documentation or explanation of how, out of the clear blue sky, immediately after her investigative meeting, I put investigative in quotes, with Todd Blanche, she suddenly is transferred and suddenly starts getting all of these extra services that even in the lower security prison, even in the club-fed prison, other prisoners simply don't get. She's in a special category of one, and they won't explain anything about that. It's just behind the wall of indifference and obfuscation that this administration runs. Let's switch over to the court. You have been a huge expert on the mischief involving the Supreme Court, on the very well-funded scheme to capture it. And right now, the NRSC case, the National Republican Senate Committee case, is once again looking at secrecy in political donations and is being asked to provide even more secrecy in political donations. Before we get to the NRSC case, this whole question of secrecy in political donations has a lot to do with how the scheme to capture the court was funded. So go back and review for everyone listening your work that has showed what that scheme looked like and how much money flowed through it.
We've never had a U.S. Supreme Court constructed the way it has been, with all this dark money backing people to be put on the court, not to follow the law, but actually to reverse legal precedents that Americans rely upon. And as you know, back in 2019, the Washington Post initially calculated the tally before Brett Kavanaugh's nomination was subject to this ongoing court capture, dark money spending. We know that at least $250 million have been raised between 2014 to 2017 in order to block Merrick Garland's appointment to the Supreme Court and push Gorsuch into that role.
And that's a minimum, because this being dark money, a lot of it remains hidden. It takes considerable investigative effort to dig that number out, which is why it took a while for the Post to figure that out. So I just want to remind everybody listening, we're talking about minimum numbers here, not the actual spend that we know of. So it started at 250, and now where do we think it is?
Yeah, and the Washington Post in that calculation included groups that Leonard Leo was on the board of, was helping to direct, or was known to have been directing. But there were a number of groups that he has been funding that weren't in that tally. It really is a conservative figure.
Leonard Leo being the little process spider in the middle of the court capture scheme, who for years has been working for the corrupting billionaires.
Yeah, he's someone who told the Washington Post documentary team that he's an ideas man. He doesn't care about money, when we know, in fact, he's been at the center of a number of these groups that have been centrally involved in the court capture, raising money from billionaires, deploying that money as well. And then he was rewarded with the control of a huge trust fund. But before that happened in 2022, when Ketanji Brown Jackson's nomination was pending before the United States Senate, we did a new tally to update that Washington Post figure, and we found that at least $600 million had been raised and spent to capture the Supreme Court and change legal policy to advance this regressive agenda. Then we learned from the investigative reporters that $1.6 billion was given to Leonard Leo to control in order to advance this agenda, both within the legal system and in culture, to change America. It's just an enormous sum. That $1.6 billion gift was the biggest gift of its time ever recorded. And it's not just that there was money that was going into, one person to redirect and throw his voice and the voice of his billionaire backers. It's not just that there was this throwing of their voice, but this has also been part of the amicus scheme, the flotilla that you've described, Senator, so well on the floor and in committee and in your books about how these groups are bringing cases or weighing in on cases to signal to this Supreme Court that's been captured that these are the cases, these are the issues we want you to take up and reverse existing law. We've seen that in the area of labor. We've seen that in the area of reproductive rights. We've seen that on Chevron environmental cases. Time and time again, what you have is this whole scheme where a huge amount of money is coming in. We don't know really all of the amounts. We don't even know all of the key funders. We know a couple of them, Barry Side and Charles Koch, for example, but there may be others. And we know also that Harlan Crow, who is the billionaire who's been padding the lifestyle through gifts of Clarence Thomas and Jenny Thomas, actually was one of the funders of the dark money group that emerged to help get John Roberts and Sam Alito onto the court in 2005, 2006.
And those two, when they got on, reversed a recent Supreme Court decision and brought the dark money into politics. They brought unlimited money into politics directly, and they brought dark money indirectly by refusing to require that the funds they allowed in be transparent. So there's a loop with dark money picking the Supreme Court that then opens up more dark money and more improper influence in American politics.
That's exactly right. And that Citizens United decision was a 5-4 decision that Clarence Thomas sat on, even though Harlan Crow had secretly staked his wife, Jenny Thomas, with a $500,000 gift to create a new group to take advantage of the ruling that the court was about to issue. And Clarence Thomas had the audacity to issue a concurrence in that opinion, saying disclosure would chill the spending of money. Basically, the arrogance of that, when he knew for certain his wife was filing an emergency urgent request to get an LLC approved. Basically, the implication is so that she could cash the check.
Well, it's not just that he knew, and that it's that she knew, and that the people backing her knew how that Supreme Court decision was going to come down. So they were readying themselves to set up the dark money apparatus they would need to move quickly as soon as the Supreme Court did what they were planning and unleash unlimited, anonymous, what we call dark money into American politics. Well, Lisa, you are wonderful to join me. Thank you for the truly heroic work you have done in this cause. When hardly anybody knew who Leonard Leo was, you were charting his flotilla of multiple phony front groups. And your work has been referenced in my amicus briefs to the Supreme Court, where I go into the Supreme Court and say, hey, those other amici, take a look at who's funding them. Take a look at how they're all linked. This is not a real thing. This is a fake orchestrated flotilla. You've been really essential to our work to bring some daylight and honesty to the court, and thank you very, very much.
Oh, my goodness. Well, thank you so much. I was reading that brief. It's excellent, as always. And I think it's so important to be making the case, making the record, so the American people can see what's going on.
Thank you, everyone, for tuning in to Making the Case.